Article 146 Committee Report on Chief Justice Removal Petitions. Quick summary of the news. The 5-member Article 146 Committee, chaired by Justice Gabriel Poimang, formally presented its first report on the petition filed by Daniel Aforinas to President John Dramani Mahama. The panel conducted hearings in camera, received testimony from many witnesses. The account of the first petition lists about 13 witnesses called by the petitioner and 12 by the Chief Justice herself, plus about 10,000 pages of documentary exhibits, and handed a sealed recommendation to the President. The committee has adjourned the second petition at the request of parties and will return with reports on petitions 2 and 3 in due course. What Article 146 requires, step-by-step plain language. First, who can start it? A petition alleging stated misbehavior or incompetence can be presented to the President asking that a Superior Court judge, including the Chief Justice, be removed. 2. For the Chief Justice specifically, the President, after consulting the Council of State, appoints a committee made up of 2 Supreme Court justices, one of whom the President names chairman, and 3 non-lawyers who are not members of Parliament or the Council of State. That committee must inquire into the petition and recommend to the President whether the Chief Justice ought to be removed. 3. Proceedings are in camera. The Constitution says these hearings shall be held in camera and gives the judge the right to be heard and to be represented. That is why the committee's public comments are limited to procedural details. 4. What the President does with the recommendation. The Constitution says the President shall, in each case, act in accordance with the recommendations of the committee. If the committee recommends removal, the President is required to follow that recommendation. If it recommends no removal, the President likewise follows that outcome. Why the committee held its hearings in camera and why people object. Why in camera? Article 146 makes private proceedings mandatory. The usual justifications are protecting the dignity and reputation of judicial officers during an ongoing inquiry, encouraging frank witness evidence, and avoiding trial by media that could prejudice later lawful processes. Why that frustrates others? Critics ask for transparency because the office involved, Chief Justice, is of high public interest, and secrecy can look like a cover-up or fuel suspicion of political motive. That tension has been a feature of commentary and legal argument around this particular matter, where this particular case stands, and immediate legal facts. The Chief Justice was suspended earlier this year after the Council of State advised the President there was a prima facie case. The President used his power under Article 146 to suspend pending inquiry. That suspension and the process have already been the subject of court scrutiny and coverage. In the first petitions hearing, the Chief Justice personally gave evidence and was cross-examined. Both sides produced large documentary records and expert witnesses. The committee has now handed a sealed recommendation to the President, a practice consistent with the in-camera rule and confidentiality norms. Legal and constitutional implications. What to watch closely. 1. Finality of the committee's recommendation for the President. Article 146 says the President must act in accordance with the committee's recommendation. Practically, that means the committee's view is decisive for the executive step. However, the process and the President's eventual action remain open to judicial review on narrow procedural or rights grounds. For example, if there were procedural unfairness during the inquiry. Expect any decisive adverse recommendation to be challenged in court. Second, impact on judicial independence. The removal mechanism is constitutionally permitted, but its invocation, especially against a sitting Chief Justice, raises concerns about separation of powers and the potential for political pressure on the judiciary. Public trust depends on perceived fairness and that procedural safeguards are strictly followed. This is more an assessment than a new factual claim. 3. Transparency versus confidentiality. Because proceedings are in camera, the public will know only slim procedural facts unless the committee or President chooses to be more open. That restraint protects reputations, but makes it harder for citizens to evaluate whether the process was free of political interference. Practical next steps and likely outcomes. The committee will complete reports on petition 2 and 3 and present them to the President. If the committee recommends removal in any petition, the President is constitutionally obliged to act in accordance with that recommendation. That will likely trigger immediate legal and political fallout and almost certainly further litigation. If the committee recommends no removal, the Chief Justice could be reinstated if suspended, and the matter would largely be closed unless parties pursue other remedies. Regardless of the committee's recommendations, expect legal challenges about process or fairness, and sustained public and political debate about whether Article 146's design adequately protects judicial independence while allowing accountability. Bottom line, this is a constitutionally structured but politically sensitive inquiry. The committee has completed the first petition, and given a sealed recommendation to the President. The Constitution makes the committee the pivotal fact finder and requires the President to follow its recommendation. Because hearings are in camera, many substantive details will remain private, which preserves certain safeguards but also raises legitimate transparency concerns. Watch the remaining committee reports, the President's actions, and any court challenges that follow. Those 3 moves will determine whether this episode becomes a one-time constitutional enforcement or a longer institutional crisis.